In December 2024, the Minister for Justice asked Lord Leveson to recommend a package of reforms to tackle the backlog in the criminal justice system. Back in December of last year, the backlog of cases awaiting Crown Court trial had reached 75,000. Today, cases are being listed in the Crown Court for as late as 2029. The problem is that far more cases are coming into the system than are disposed of at the other end, and the backlog is growing all the time. So, Leveson's task was to propose some radical reforms which would enable the backlog to be tackled very soon. Leverson was asked to report in two stages. The second stage will relate to efficiency within the court system and will probably focus upon disclosure and digitalisation. The first report, called the Independent Report into the Court System in England and Wales, has been published and was released on the 9th of July this year. The report has attracted a certain amount of controversy because the focus has been on Leveson's recommendations regarding jury trial. The overall effect is that Leveson would create a new division of the Crown Court composed of a judge and two magistrates, which would hear very many cases which at the moment might be heard by a Crown Court sitting with a jury. The net result will be there'll be far fewer trials by jury altogether. I don't actually intend to say anything about this set of reforms today, partly because it has been so well covered elsewhere, and for that reason, other aspects of Leveson's report have not received the attention they might have deserved. So I'm going to try and focus on those aspects now, and in particular, I'm going to make some observations from the report regarding Leveson's interactions with the players in the criminal justice system. Lord Leveson has clearly been speaking with many judges, magistrates and criminal practitioners and prosecutors, and a lot of recommendations which are included in the report result from these conversations, and they are worth further attention. Let us start then with the police. At the moment, the police have the power to charge a number of low-level offences. Lord Leveson believes they are charging too many such offences when the offence is relatively minor and it might be possible to dispose of the case in another way. Leveson recommends that the possibility of deferred prosecution should be rolled out nationwide. There are already 14 police forces which are operating a deferred prosecution scheme, but there are 43 police forces altogether, and Lord Leveson wants the rest to follow suit. The point of a deferred prosecution is that you may have an offender who's committed a very low-level offence and is possibly a young offender and may grow out of this habit. And the question arises as to whether we really want to give this person one more chance rather than put him through the system with the taint of a criminal conviction hanging over them for the rest of their lives. The point of a deferred prosecution decision would be that you simply wait a bit and see what the suspect does over the course of the next 6 months or the next year. If it's clear that the suspect is already taking measures to change their ways and has stopped reoffending, then the perceived need to charge the suspect, which might have been thought to be the obvious thing to do shortly after the offence, may seem considerably less obvious just 1 year later, and it might now be possible to make a decision to spare the person the criminal process with a much more legitimate reason for doing so than if one had not waited at all. In other words, where the defendant does not pose an obvious risk of serious reoffending, Leveson's message is maybe sometimes we should simply wait and see rather than hurry our decision. Related to this is the matter of out-of-court disposals. These are available in various forms in England and Wales. Perhaps the best known ones are cautions and conditional cautions, whereby the offender who admits their guilt may be spared prosecution, but the fact that they have accepted the caution or conditional caution and have admitted their guilt by so doing does stay on the police national computer, and so it does have some possible further consequences down the line. Nonetheless, even this is still better than going to court and getting a criminal conviction. The problem is that the practice of out-of-court disposals varies again because there are 43 police forces, and it would seem that when the police do make a decision to charge a suspect or send the papers to the CPS with the request that they authorise that a suspect be charged, the possibility and propriety of an out-of-court disposal often falls between the two gaps. Leverson is proposing that in all areas the police and prosecutors have a clearer joined-up strategy in deciding whether it is possible to dispose of a case with an out-of-court resolution. And he also proposes that more nationwide guidance be available so that practice becomes more uniform in all police areas in England and Wales. He admits that this will require a lot more liaison and considerably more resources than are available at present. One reason why some police forces might be anxious about a conditional caution might be the lack of support. By this, I mean supposing that the police have caught somebody in possession of drugs, and they may be concerned that this person should attend a rehabilitation course in order to tackle the habit and to stop that person from being sucked into more serious crimes in order to feed the habit. The problem is that it is not obviously the case throughout the United Kingdom that there will be effective drug rehabilitation provision. So if we're going to divert more offenders away from court, there has to be a better support apparatus to deal with some of the needs of some offenders. Leveson recognises all this, but his view is clear that the cost is worth paying and it will contribute to tackling the backlog. It's hard to disagree with any of this. It should be added that reforming the cautioning system is easier said than done. At the moment, cautions are only available where the suspect is prepared to admit their guilt. That might be something to be revised. The Lammy report in 2017, of which Leveson is well aware, points out that many defendants from ethnic minorities are unwilling to admit their guilt to the police at all, and so they are effectively excluded from many out-of-court resolutions which would otherwise be in everyone's interests. It may be that a more thorough revision of the rules of cautioning and other out-of-court disposals should tackle the vexed question as to whether the defendant should necessarily have admitted their guilt before being offered the opportunity of an out-of-court resolution. Another ongoing problem with cautions is that the government is always tempted to tinker with the system. At various points over the last 20 years, the number of out-of-court resolutions has risen, and certain parts of the media have got hold of these statistics and have portrayed them as being a license for criminals to get away scot-free with their activities. As a response, governments have passed legislation designed with the hope of making it more difficult to get a caution. At some point, this back and forth has to stop. Leveson's hope is that a national framework which works can be agreed upon and that the government will be able to resist tinkering with it under media pressure. We shall see on that one, but certainly the aspiration seems to be well placed. Now we say a bit more about prosecutors. Leveson is careful not to say that he believes that prosecutors too often overcharge and bring cases to the Crown Court which do not strictly need to be there. But although he doesn't say it, there are certain hints to that effect. He cites academic research to that effect, and there is a pointed example given at one stage about the charging of robbery. When a person is deprived of their mobile phone in the street, a very common sort of crime these days, it is possible for some light force to be used in taking the mobile phone from the offender. So prosecutors have a choice. They can charge theft, or if there is a slight use of force involved, they can charge robbery. The problem with charging robbery is that it is a much more serious offence, indeed it's an indictable offence, and it has to be tried at the moment by a Crown Court and jury, even though the defendant, if found guilty, would likely not receive a sentence which would be in excess of anything which a magistrate could give him if he were tried at the magistrate's court. So there's a clear lack of efficiency in routinely charging robbery in such cases, and Leverson says this is a case where robbery is sometimes charged, whereas ordinary theft ought to be charged. It's a telling example, and one which I think suggests that he is nervous of overcharging in some areas. As to whether he has a solution to this, that is less obvious. When the Ministry of Justice commissioned Lord Leveson to start work, they also approached a number of criminal practitioners and stakeholders, including academics, for their own views. And I was asked for my views about charging in the UK, which is very hard to do. But I did make a suggestion relating to the lack of a power which a Crown Court judge presently has to stay a trial which has been overcharged. At the moment, the leading case is one called BKR. This is a case decided 2 years ago. Originally, Mr. BKR was charged with several sexual assaults. He was willing to plead guilty to most of them and received a substantial prison sentence for all those offences combined. What Mr. BKR was not prepared to do was admit guilt on one particular sexual assault charge. Now, the CPS could have left the matter there because the trial judge before whom all of these offences were originally listed said that even if BKR were to be guilty of that other sexual assault, it still wouldn't add anything to the sentence he'd already received for the considerably higher number of other sexual assaults. That's the way sentencing works. You don't keep on adding 6 years after 6 years after 6 years all the time. So when the CPS insisted on BKR being tried for that one count which he denied, they were seeking to try him for something for which, even if found guilty, he could not be sentenced to any further jail time. For that reason, the trial judge did not want the trial to go ahead at all, because he saw it as a week of court's resources being spent on a trial which had no possible consequence, when he could see for himself how long the list of cases waiting to be tried, where there might be actually something at stake, was. But the CPS refused to withdraw the charge, and when the Crown Court judge tried to stay the trial, the Court of Appeal overruled him and said he did not have the power to do this. My suggestion to Lord Leveson's review was that legislation ought to create the power for trial judges to stay proceedings where no possible consequence can befall the defendant, even if convicted, and subject to other safeguards as well. The BKR example isn't the only one. We quite frequently see very elderly defendants prosecuted for offences alleged against them some 30 or 40 years in the past, and quite often it's a good bet that the defendant will not actually live to see the end of the trial, let alone serve any meaningful punishment. If we are serious about tackling the backlog, and if the CPS are still insistent upon charging these cases because they regard the offences as serious, in my view, it might be appropriate for Crown Court judges to have, in extreme cases, the power to stay the trial. If nothing else, it might make the CPS think more carefully about the need to put certain cases through the court's system. Finally, Lord Leveson has various recommendations concerning practitioners. He is concerned by the lack of effective legal aid for many defendants who are appearing in a magistrate's court. He is concerned about the lack of criminal practitioners coming through the bar. The problem is that not only are many young barristers leaving the criminal bar, but it's just as difficult for those who are determined to join them to do so, because so few criminal sets have the money to offer pupillage. Leverson quite radically recommends that the government should be prepared to match fund certain pupillages for criminal barristers in order to get more criminal barristers into the system. It's something which a government has been, all governments of all colours have been very resistant to do. The idea of governments funding lawyers can create rather unwelcome headlines. But Leverson is clear. If we're going to tackle the backlog, we also need effective practitioners, both prosecuting and defending, um, and that if people are not going into crime, some money is going to have to be found to mend the problem. He also recommends um, measures designed to improve legal aid at police stations. Going back to our problem earlier about defendants having the possibility of admitting guilt and then being eligible for an out of court disposal, defendants are much more likely to confess their guilt with the hope of being offered such a disposal if they actually have a solicitor or trained legal advisor with them at the police station advising them of this possibility. So putting more funds in to uh, securing better advice for defendants at police station is a good economy because it means that more people who are genuinely guilty are likely to be encouraged to plead guilty and avoid unnecessary court appearances. Well, there are various other recommendations of Leveson. I haven't got time for them today. My real purpose in this video was simply to say there was so much more to Leveson's first report than his proposals to reduce trial by jury. In particular, he says that all of his recommendations will be needed, so the government is going to have to fund better mechanisms to dispose of people who need drug rehabilitation or other forms of treatment as an alternative to being prosecuted. The government is going to have to find some money to persuade more capable barristers into criminal practice. And the police and the CPS are going to have to work better in diverting suspects away from court when it's not strictly necessary. It's a lot to ask, but according to Leveson, all of this has to happen too.